Hi, everyone. Let's talk about the U.S. Supreme Court's opinion in Morrison versus Olson. This is a case that you'd probably read either in constitutional law, administrative law, or both. It was a majority opinion by Chief Justice Rehnquist and had a very famous dissent by Justice Scalia. So, what went on? Title VI of the Ethics in Government Act allows for the appointment by a special division in D.C., that is, a court, of an independent counsel, and that counsel gets to investigate and prosecute certain high-ranking government officials for violating federal criminal laws. The counsel can only be removed from impeachment or conviction or by personal action by the Attorney General for good cause. So originally, McKay was appointed as the independent counsel, and he was investigating testimony and revision of that testimony from Ted Olson and whether that violated federal law. Ted Olson was from the Reagan administration. McKay later resigns, and Alexa Morrison replaced him. So that's where you get Morrison in the Morrison versus Olson. She is the petitioner. So the big question here for the court is, with this good cause standard, is there a constitutional violation? And does the president need to be able to remove this officer from office? So this goes all the way back to a case called Myers versus United States, which broadly held that the president does have a strong removal power, the power to remove officers who exercise executive duties. Removal is something that's not really in the Constitution that much. Appointment is, but removal is not. So there's a lot of things to figure out here. So the Supreme Court ends up holding that this is not a violation of the Appointments Clause or the limitations of Article 3, nor do they impermissibly interfere with the president's authority under Article 2 in violation of the separation of powers. So it is okay that there is a good cause removal provision. The independent counsel does not unduly interfere with the executive's power, and that's something that's pretty important, undue interference. The good cause standard for removal doesn't burden the president's ability to control or supervise the independent counsel as an executive official. Congress did not increase its power at the expense of the executive branch, and they didn't even give themselves power outside of the power of impeachment over the independent counsel. The executive, through the Attorney General, still has power to remove the independent counsel here. So that is something that looks good to the majority about this act. And they talk about inferior officers versus principal officers. Now, principal officers are the highest types of officers. They exercise a significant amount of power pursuant to the laws of the United States. Inferior officers are those below, and with those officers, Congress can vest the power to appoint them in the courts of law or the president of the United States. The president does not have to appoint them, and the president does not necessarily need to be able to remove them. So they're inferior officers, they're not principal officers, and they give 4 reasons for this. They're subject to removal by higher executive branch officials. The act only empowers them to perform certain limited duties. Counsel is limited in jurisdiction. They can only act within the scope of the jurisdiction granted by the special division, that court in D.C., pursuant to a request by the Attorney General. And the counsel has limited tenure, even though there's no specific time limit. Once a task is done, the office is terminated. So this isn't really a permanent thing. There's not someone who's serving as special counsel forever. They're just on it for one task. So then we get Justice Scalia's flaming hot dissent. Criminal prosecution, he says, is a purely executive power. This act deprives the president of the exclusive power. Since this act vests purely executive power in a person who's not the president, it should be struck down. And then he points out the majority admitted that there's no real dispute that the functions performed by the independent counsel are executive. And then they uselessly qualify that concession with saying, in the sense that they are law enforcement functions that typically have been undertaken by individuals within the executive. He also disagrees that these are inferior officers. So here's some of the issue with Scalia's dissent, is that he thinks that all powers which are by their nature are executive should be considered executive, rather than powers that the Constitution simply says are executive. So he's saying that the majority admitting that the independent counsel's powers are executive means that they're admitting that they should be able to be removed by the president. But he doesn't see that the majority views it differently, that exercising executive powers doesn't mean that you're exercising executive power as the Constitution sees it. It means you're exercising powers that are executive in nature. So that's Scalia's dissent for you. Let me know who you think is right in the comments. And as always, if you found this video interesting, insightful, or helpful, please do leave a like, comment, or subscribe. I hope that you can get an A+ in your constitutional law or administrative law class, whichever one you're taking, or that you can use this case if you're litigating. So yeah, thank you for watching, and I look forward to speaking to you in the next video.